Yeah, hi, small business owners. It's Harpreet Singh from Western Law Firm. So today I want to talk about the important day, your day in court in a small claims case. So we have, I think, covered all the process of small claim, how you can begin the process, the different kind of forms which you have to use, and in the middle of the process before your trial, what are the things or steps you can take for different to handle different kind of situations. So now it's your day in court. So the first thing you have to do, obviously, before this day in court, you would be preparing for your hearing, which would include preparation of all the documents. Either it's your evidence, you are collecting it, or either you are drafting a summary of your story so that you can provide it to judge, or if there are a number of documents, so you are creating your exhibit list so that you can keep track of as you provide your story to the judge that you have checked this box or you have indicated this particular fact to the judge. So you covered all your bases, either it's your claim or your defense. So the most important things are the documents, obviously, and it will also depend on your case, because if your case is about contract, obviously your contract would be the most important document. Any modification made to that contract, any emails, because nowadays people talk a lot on emails, and also text messages, because at least if there is no written contract, usually I think there is some conversation going on text messages. So you need to print those messages between defendant and you to just establish, okay, what we were discussing about this particular situation, transaction, or there can be other people who may have text messages which you want. So you have to gather all those documents and prepare a exhibit list, which is just a checklist of all these documents, so you can make sure in court when you're presenting your story that, okay, I have mentioned 3 documents, okay, next I will mention about another 3 documents. So you don't miss things on your story. If you have 10 things to cover, obviously it's really very hard sometime, if you are not doing it frequently, that you will forget about, maybe you have to discuss about document number 8, because the small claims hearing, it's very informal. When you are there, plaintiff is standing on one side, defendant is standing on other side, and the judge will ask the plaintiff first that, okay, Mr. Plaintiff, what's the issue? So the plaintiff presents their story, they present documents, and judge can interrupt if judge have question, or judge just may skip and just ask for, okay, why not you just provide me your contract, because sometimes judges maybe missing your point, or it's hard for the judge to understand, because sometimes people get so much emotional, they just don't present their story coherently, so they are just skipping, I think, their own line of thought, and they are just presenting some bunch of unorganized I think statements where it's hard for a third person to understand what's going on. So judge may interrupt you and just ask, okay, why not you provide me this contract? Okay, why not can you provide me any emails you have or any text message you have? Or judge may say, okay, you're talking about this fact, okay, can you search in your bunch of documents, do you have any email? Because sometimes if you have big stack of document, it's hard for a judge, so judge would need your help. So it would be in your favor. I think it would help you a lot if you are organized yourself, so that you can assist the judge, because judge don't want to spend more time if it's needed, because there are all other cases which are which are pending after you. So So it would be a great help to the judge if you already have organized all your documents, and whenever judge asks for any document, you just provide that. If in case, suppose, because sometimes judge is interrupting you and hearing the story, and if there are like 4 other documents which are missed, so this checklist would be really helpful. So then you can indicate to judge, because at last, when judge thinks like almost all things are covered, judge will ask you, is there anything, any other thing you want to add? Then you can mention, okay, yeah, sure, judge, I have these 4 other documents I like you to take a look on and then decide about my case. And the same thing with the defendant. Defendant would obviously have their own documents based on their defense. So the same thing, the defendant also needs to be organized, and so that the judge can understand what you're talking about. So documents are the important thing, and then comes the witnesses, because in some situation, especially when there is only phone conversation going on, and there is maybe some witness to a particular meeting which happened where there is no documentation, then obviously to prove your case you need witness. So to bring witnesses, either I think it's always good to bring witnesses voluntarily. Just mention them about, okay, my hearing is on this particular date, can you please come at this particular time, and I would need, because usually small claims, it would usually take 30 minutes or so, but you have to think about, because the hearing time which is mentioned on your complaint, that's a general time. That's the time of the session when the court starts, either in the morning or in the afternoon. So that's not the time when ultimately your case will be heard. It may be like half an hour after that, or it may be your case is at last. So maybe it's like you have to wait for 1 hour. So just provide that time frame that my hearing is in the morning, so it would need like 2 hours or so. Or you can ask the judge, okay, judge, let me contact the witness, if your witness is probably just living nearby court. So you can, I think, ask your witness to be at the hearing, because witnesses are very strong, as also similar to documents, especially witness who is testifying in person. And because I think the judge can cross-examine the witness and ask, okay, you were present at that meeting, okay, why you went with this person, okay, what's going on. So the judge can assess the credibility part of the witness's testimony. If in case, and it happens because a witness just don't like to come, so at least you need, I think, a declaration from witness. If you cannot ask that witness, or it's difficult for that witness to show up on the hearing, so you can at least get a declaration from the witness. So when you go to your trial for small claims, you can present that declaration to the judge. Okay, judge, I have asked this witness, but there was some issue, or he didn't have time, so he have provided me this declaration which proves this particular point. And your declaration needs to be under penalty of perjury to be having some teeth in it. Otherwise, I think the judge may still look at it. It just depends on a particular judge, but still it's not that much effective, because it's not under penalty of perjury that this person is just making a bunch of statements without thinking about any consequences. But if there is penalty of perjury clause at the end of the declaration, it has weight, because obviously the person is thinking, yeah, this statement is serious, I have to tell the truth. So at least you should, I think, bring a declaration from witnesses to prove your point. So but there can be, I think, another situation. Maybe your witness is not voluntary. Maybe that witness is probably more aligned to the defendant, but not kind of friends of defendant. So probably there is also another risk. I think if you I think if you bring that kind of witness, that witness can I think say statements against you. So you have to think about your whole situation. So I think, but still, if you need that kind of witness to be present at the hearing, because usually this kind of a witness, maybe you can think about some government employee, maybe some city employee, or maybe a police officer or someone. So you have to make sure you need to subpoena that witness. So subpoena means it's that you are involuntarily asking them to appear at court. So there is a form for that. So you have to have a stamped form from the court's clerk. So it's SC 107 in a small claims case. So you just fill this document, present to the clerk, and the clerk stamps on it. Then you have to serve that document to the witness, the person who you want to be on your trial for their testimony. So, and also you have to make sure if they ask for a witness fees, there are witness fees because you are asking this person involuntarily to be at a particular day, at a particular time, to be at some place. So there is a fees involved with that. So that's, at present it's $35, and then there is also amount which you have to pay based on mileage. It's 20 cents per mile. So if the person is living 100 miles, so you can just calculate based on that, because obviously it's very fair, because you are asking a person who don't want to get involved, and the person is not a defendant, so that person needs to be paid. And this is a very low amount, means you can think about $35, and that person probably coming from 100 miles. So you can think about like what would be the wastage of time for them. But sure, it's important for you, so you have to pay those costs if the witness asks you. So this is the preparation part. I think once you provide your story to the judge, usually if there are like more documents involved and your case is not on the face of the contract itself, then most of the time the judge will take under submission your case and not provide your decision at the same time. But if it's a very clear-cut case, not much documentation involved, not much research about legal issues involved, because sometimes there comes a legal question. Either this person has breached this contract, or this contract itself is valid or not. So maybe the judge has to do some research. So judge will take under submission and send you the decision in the mail, probably I think within 30 days or so. So you just wait and just look for the decision in the mail. So once you are done with that, so what are the post trial I think rights of either plaintiff and defendant? So if you are a plaintiff and if you win your case, that's good, congratulations. So you received the decision in mail, and the judge mentions, okay, I am just ruling in favor of plaintiff, and I ask defendant to pay this much amount. So that's well and good. Then obviously the court will also provide the decision to the defendant. So now the next thing is that you have to recover this amount. So the defendant has 30 days. If suppose defendant appear at the hearing and defendant lost, defendant has 30 days to just pick up their next step. And the defendant, either they can file an appeal, or the defendant can just pay you, and after that point you have to just file a statement of satisfaction of this judgment once you receive all the amount. Or the defendant, if suppose defendant has not appeared at the hearing and the plaintiff got a default judgment, then the defendant can file, once the defendant receives the judgment, can file the document or a motion which is called to vacate the judgment. So that's basically will ask the court that the court should vacate a judgment based on some good reason. If the defendant doesn't appear, maybe there can be medical emergency or some accident happened with defendant while they are coming to court, or some other good reason. So there would be another hearing set. Until that point, the plaintiff cannot recover their judgment. So, and also there is a whole lot of like collection part of it. So once, if the defendant is not paying you that amount after 30 days, so what are the steps? So I will discuss that in a separate video that would be called collections. So because because there are different options you can use for collection purposes, and in itself it needs a video. So I will just discuss all those steps afterwards. So if suppose defendant doesn't take any step, either defendant doesn't file an appeal or the defendant doesn't file a vacating the judgment part, or and defendant just still didn't do anything, but the defendant has one duty: within 30 days of receiving the judgment, the defendant has to provide a document called the judgment debtor's asset information, which basically provides information of defendant's assets to the plaintiff. So that would assist plaintiff in terms of collections of this judgment amount. But usually, I think at least the small claims, when I was volunteering during the my small claims clinic while I was in law school, I have barely seen, I think, any defendant providing that kind of document. But there are like also steps which you can take, and I will just talk that I will talk about that in later video. So let's come on, I think, the defendant side. So defendant lost. So what are the rights? It's the appeal right, which we have already discussed. And also it would be good to discuss about what if the plaintiff loses the case, and if the plaintiff is only the person who filed the complaint. And this is really very important. If you're filing a small claims case, if you are a plaintiff, if you lose, there is no appeal right. I again say there is no appeal right. So you cannot file an appeal, have another small claims hearing. That's only allowed for a defendant. But sure, you have to understand, if defendant file a cross complaint, which is basically there is another form which defendant files and say, okay, this person also owes me so and so money. And in that situation, basically defendant becomes a plaintiff in their case on their complaint. If plaintiff loses that part, then plaintiff can file the appeal on defendant's complaint. So there can be another hearing which is similar to this hearing, because usually in small claims case, it's like another trial. You will try it again with another judge. So it goes to an appellate level division within the superior court, within that same court where you went to small claims. So probably the courtroom would be different, obviously, but there is another appellate division for small claims within that same court. So your case goes there, you will get a new hearing date, and again you have to just do the same thing. But if again you lose, then there is then obviously there is no other way to appeal, other than if you think the judge abuses their discretion. There are different writs you can file. This is with like very advanced, complicated stuff, and like very rare, I think, writs are accepted, because there is not much practice done on, because it's small claims. The amount itself is that much that it probably, you would think, it would not worth the purpose. So you have to keep in mind, if you're plaintiff, that there is no appeal if you lose, and that's done. So you have to be careful. If you are, I think, filing a claim, your claim is adjudicated at that point. And if you think about later, oh, probably my damages were like $50,000 and I should have tried this case in like a general civil court, unfortunately you have just lost that opportunity, and you cannot do anything. And on the defendant side, you can obviously file another appeal, another hearing after, depending on the county, either it's 3 months after or 2 months, and defendant have another option. If they just fail to appear, they can ask for vacating the judgment, and if there is good cause, defendant will again get another hearing, so then they can have a judgment. So in the next video, I will be talking about once you have a small claims judgment, how you can recover that, and those options will also apply to your general civil judgments also. So I think the next video will provide you more insight that it's probably, you will think it's easy to get the judgment. You just have to go one day in court and present your case, and probably collection in itself is another headache to take care of. So we will discuss about different options which you can use to collect the judgment. And again, I'd like to thank you for watching these videos and just being with this page, so we can just provide you general legal information. And also, again, this doesn't establish any attorney-client privilege, attorney-client relationship. So you have to think about your particular case and get advice of a legal professional. So thank you again for watching this video. Thank you.